Okay, you mentioned detention and demurrage and some of the progress you've been making there. I'll just unpack that slightly for our listeners who mightn't be following that quite so much. In February, a final rule on demurrage and detention billing practices was published following a unanimous vote of the five commissioners. The rule establishes requirements for how common carriers and marine terminal operators must bill for demurrage and detention charges and provides clarity on who can be billed within that time frame. It also specifies the process for disputing bills. This took effect on May the 28th. So how does this change things for shippers? Is there anything they should be doing differently in light of all of this disruption we have at the moment in terms of what they do on contracts with carriers or forwarders or railroads, or in terms of checking their invoices?
Yeah, I mean, we may want to get back to the contracting issue, but not necessarily because of the D&D rule per se, but just because of the way the industry is changing. But in terms of the detention demurrage rule per se, it does a lot in terms of guaranteeing to a shipper that when they're billed, there's got to be enough information to really understand what that bill was all about. And it has to be done within 30 days. And the company, the ocean carrier or the NVOCC has to give 30 days to the shipper in order to dispute the bill. So I do think that, and it doesn't, by the way, mean that a bill can't be disputed beyond that, but that there has to be that 30 days given. To me, what that means for ocean shippers is in order to get full advantage of this, they really should review their bills carefully. The whole point of it is to connect what's going on in the supply chain, whether boxes are being moved with the goods to their final destinations and unloaded, and then whether that box is returned. It's to connect that to the charges. The challenge that happened during COVID was either whether it was reality or perception or became both, that connection was lost. And therefore, American shippers, importers, and exporters felt that they were going to have to pay these huge charges no matter what they did. And so they stopped doing it. Truckers sometimes were locked out, even if because of a disputed bill on one of their customers, they couldn't pick up for any of their customers. This all added to congestion, the opposite of what the system was supposed to do. So by setting up these rules, it makes it more clear. Every now and then you do hear a hypothetical about, well, wait a minute, hold on. What if we don't get back to you in 30 days? And what if our trucker didn't pick it up or did pick it up, and then we got the bill and the bill, and then we paid the bill and sent it to the trucker, and the trucker said, well, I picked it up. So there is one piece of advice. None of that, by the way, you'd still have the right to dispute it if you paid a bill and it was wrongly billed, even if it was after 30 days. But forgetting that, you should keep an eye on your supply chain. Shippers should understand and should know if they send a trucker to get something within 30 days, maybe not instantaneously, but within 30 days, should know if that shipment actually got there. And if you don't want to do that, there's plenty of 3PLs that will take care of the whole process for you. But if you want to be the shipper of record, you should keep track of your supply chain enough to know what your trucker is doing. I would think most of the listeners to your program already do that and do it very, very well. But maybe that's the key thing, is that if you don't have a good sense of what's getting charged detention, demurrage, and why, now that this rule is in place, the carriers have to tell you. They have to give you that much information. And so I guess it would just behoove shippers to make sure they're paying attention. And if they are paying attention, I don't think they'll have any problem challenging the bills that they know are, that didn't really happen. And most of the time, by the way, they will have success. The carriers will acknowledge it. Everybody makes mistakes. This isn't about playing gotcha. This is about getting the system right so that we keep cargo and equipment moving.
Okay, I'll come back to that challenging process in a moment and who has access to it. But the incentive principle. So this is the idea that a detention and demurrage charge has got to be reasonable. It must help promote the efficient movement of cargo and or equipment and not be for some other purpose. Now, in light of what happened during the pandemic and what might be brewing right now, that some other purpose, there's been accusations thrown around in the past that, that other purpose could be making money. Are you happy that the powers that you have now satisfy the incentive principle and protect US shippers?
Look, I don't think anything is perfect. I certainly don't think any rule or regulation is perfect. So we're going to have to keep on, once we've experienced this a while, once we've seen some cases, we'll have to take a look at it, and there may have to be additional rules. We may have to make adjustments, but that's true for anything in government, at least if government is open-minded and responsive to the people it's supposed to be serving. I will say this. First of all, the incentive principle is articulated so simply, and you did a very good job just then, but it's easy to sort of say now, but it was first articulated by Commissioner Rebecca Dye, our most experienced commissioner. I think when we look back at supply chain history in 50 years, this is going to be a major thing that students cite. I think it is really that important. And Rebecca's work on that, she's still my senior Republican colleague, is very, very important in sort of leading to that. Look, it's not that we don't want the carriers to make money. We want them to make money, but we want them to make money in an honest and transparent way on the rates. The rates, what the market is, et cetera. The problem with where detention demurrage went is that what they were saying was for a detention or demurrage reason was often perceived, and perhaps perceived correctly, to really be just a stealth way of increasing the bottom line and not really to move cargo. And this corrects that. So look, if the demand is there and the carriers say, well, we need to up the rates because of supply and demand, they can still do that. There's nothing that we're going to do to touch that particular market. All we're doing is saying, if you're representing a charge as you didn't pick up your full box or you didn't return your box on time, then that has to be honest.
Yeah, separating the rates from surcharges and other fees is quite difficult when you look at some of those bills, but I'm sure you know more about that than me.
Well, I'm learning more. I mean, I think it is just the beginning. By the way, of course, as we know, anyone knows who has cable television or mobile phone service or gets on an airplane, there's all sorts of, this is not the only industry, in which case there's all sorts of fees and stuff that, it's part of modern life. But I think to the extent the market works better, the more transparent it is. When I get on hotels.com and I look by hotel price and I say, oh, here's one that's, $250 a night. I stay in important cities, I guess. Here's one that's $250 a night, and here's one that's $350 a night. Well, I'd rather go on the $250. I click it and I see that there's a $150 resort charge. Well, that's not being very honest, is it? So what we need to, generally, I would like things to become more honest, but we'll start with detention and demurrage charges, because if they're not honest, then when something comes along like COVID and that kind of demand boom, the entire system gets clogged.
I'm just wondering where you're up to in terms of getting rid of that backlog of claims from during the pandemic. My colleague at the Lodestar, Alex Whiteman, he tracked down 38 claims worth around $67 million against various carriers and forwarders. These included a few big ones, the now bankrupt Bed Bath & Beyond after $31 million against Evergreen MSC Yang Ming. There was Gitty and Peloton are after quite a lot of millions from Flexport. Is there a lot of claims still out there that date back to that period?
Yeah, I would say quantity-wise, we've taken care of a great many of them. There are certainly a number of outstanding ones that are pretty newsworthy, and you just mentioned a bunch of them that will take some time to litigate. And of course, I can't speak to any particular case, but I think we made great progress. And when I say we, though, I really should say the whole industry as a whole. I mean, I know that the carriers sometimes get tired of criticizing me, and I may criticize them later on this podcast, but a good portion of them have done a lot of work in trying to adjudicate these claims, come to settlements, et cetera. So I guess I would say I'm happy with the progress we've made there, but certain kinds of disputes will take a long time to play out, and we want to make sure that due justice is served. So some of those cases continue, and a lot of them, by the way, are elongated by agreements between both parties. When they come before an administrative law judge at the commission, they set a deadline, et cetera. When that deadline is broken, we have to approve the extension, but we generally only approve the extension if all parties are in agreement on that.
Just listening to some of those names that I threw out there, we had Peloton, Flexport, the big carriers. Are you happy that SME shippers have got access to all of the dispute mechanisms that you're making available? Because quite often there's a big imbalance between a small shipper versus either a large forwarder or a carrier or a railroad. Are you doing anything to help make that, maybe provide legal assistance or financial resources, so that every man, every forward, every shipper can access the FMC's dispute mechanisms?
That's certainly an ideal that I would like to achieve. But the law, it doesn't give a special boost or anything. But what it does do is it allows the FMC itself to bring cases. We have a very potent enforcement division with much more teeth than it used to have because of the added resources in OSRA and a reorganization that we did a couple of years ago. So part of that is that, yes, if you're a big company, a big shipper, you can bring your own private case and have your own lawyers argue it. But if you're not, the FMC can still bring a case, and you still have many different avenues. The other thing that, of course, we do have is a consumer affairs division that can advise you, and you don't necessarily, have to file a case. You can come to them and just ask, well, what are my options? And those are all very important things. Again, fmc.gov will get you to a platform where you can sort of access where all of those various services are. So yes, I certainly think that it's very important that there be fairness across the board, particularly because the larger you are, in some cases, that does give you more market power. And in a free market system, which ocean shipping is since deregulation in '84, it is going to have certain advantages. But we do try at the FMC anyway, when it comes to dispute resolution, to make it as fair as possible to every player, particularly, look, I was a congressman from a very middle class, working class farm cities, but farms as well, district, and it's still in my blood. Is trying to protect the family business and the relatively small agricultural exporter.